Ayan nga, video.
Kasi nag-uusap sa'yo.
Let's go na. Ayan.
Sa ating mga viewers, don't forget, support Cordillera Daily. The best.
Then sabi hinirang ng langit, basahin mo lahat, pati yung mga binasa ko at kung sino ang tatay ko. Sabi ni hinirang ng langit.
Alright, so dandahan natin basahin, ano? Okay? On appeal is the judgment dated for August 2022 of the Metropolitan Trial Court, Branch 28 Manila in criminal case number MNL 20041880CR, finding herein accused appellant Norman Mangosen E. Antonio alias Francis Leo Marcos Antonio guilty beyond reasonable doubt for violation of sections 1 and 3 of Commonwealth Act 142 as amended by Republic Act 6085 or anti-alias law. Ito po yung unang decision.
Pakita din doon natin na March lang pinirmahan.
Ipakita mo na rin na po na March 1 lang po na.
So, March 1.
Sige, paki-closer. Don't move. March 1, 2023, nakalagay po dyan mga kapatid sa nakikita nyo po. You are hereby notified by those presents that on the 22nd day of February 2023, an order was issued in the above, palapit, di ko makita. In the above entitled case, copy of which is here to attached. Manila, Philippines, March 1, 2023.
Okay, so basahin po natin kung ano talaga nangyari doon sa kaso na yun, ano? So,
Sabi po pala ni Hinirang ng Langit, President, masyado nila niyurakan ang pagkatao ni FLM but now he is vindicated.
okay.
Sabi din ni Hinirang ng Langit, masyado nila niyurakan pagkatao ni FLM but now he is vindicated. Pakita niyo rin kung sino-sino ang complainant.
Ang complainant po ay ang nag-file po talaga dito ay ang Cybercrime Division. Ito po, Mark. Cybercrime Division ng National Bureau of Investigation. So sila po ang nag-file ng kaso sa anti-alias. And ito po ang nagiging basahin po natin kung ano talaga yung nagiging nangyari dito, no? At paano natin or pinaglaban ng ating abogado dahil nakita po nila na talagang wala pong kasalanan si boss. Okay, so portion of the decision is ito po, basahin natin. The prosecution alleged that considering that the accused appellant used an alias named Francis Leo Marcos since 2007 and he only became a social media sensation this 2020. He is not one of those who are allowed to use the same. To prove their allegations, the latter verified that identities of Norman Mangosen E. Antonio, Francis Leo Marcos E. Antonio, and Norman Alejandro Antonio to the Philippine Statistics Office and Land Transportation Office, PSA submitted a compliance manifestation dated 4 June 2020, which started that only the certificate of live of birth of one Norman Mangosen and Antonio exist in the records and that no records of birth existing under the name of Francis Leo Marcos E. Antonio and Norman Alejandro Antonio. The LTO, on the other hand, issued a certification dated 6 June 2020 of the driver's license data of Norman Mangosen, which matches one that they have received through intelligence gathering. The said license details bears the face image similar to the one posing as Francis Leo Marcos E. Antonio. Also, upon inquiry to the office of the Civil Registrar General in Baguio City, where Francis Marcos claimed to have been born based on various documents he filed out, the said office issued a certification stating that there is no record of birth under the name of Francis Leo Marcos. To rebut the evidence of the prosecution, the defense presented Rico Peñaranda and Remedios Magosen. Okay, so Remedios Magosen, the mother of the accused appellant, testified that during the childhood of her son, he was known in their place as Enzo or Norman Lorenzo. Her son was born on 29 December 1979 in Bulacan. After she gave birth to Francis Leo, Dr. Pacifico Marcos registered his birth in 1996. At the age of 17 years old, Francis Leo went to Baguio City and lived there together with the Fortuna baby Barba. At that time, Dr. Pacifico Marcos and Fortuna baby Barba were calling his son Francis Leo Marcos. Upon the query of the court, Remedios Mangosen declared that upon giving birth to her son, he registered him as Norman Lorenzo Mangosen with her as his mother and his husband or her husband, Gilbert Mangosen, as his father. She also registered Bulacan as the place of birth of her son. On August 4, 2022, the court promulgated the appealed judgment that is positive portion of which reads, wherefore, ito na po yun, wherefore, tapos na po yan. So ito po yung decision ng August 4. And basahin po natin dito, medyo mahaba po kasi ito. May mga jurisprudence po dito. So, dumiretso lang po tayo dito. Moreover, the event about which Okay. Now, for using Francis Leo Marcos and Antonio Marcos, a name different from his registered name at birth of Norman Antonio Mangosen, in several documents, the court in its judgment dated 4 August 2022 convicted accused appellant for violation of sections 1 and 3 of Commonwealth Act number 142 as amended by the Public Act number 6085. This court, however, upon perusal of the judgment dated 4 August 2022, finds that the court overlooked and failed to take into consideration the decision of the Supreme Court in Orsua versus Court of Appeals. Under the doctrine of stare decisis, when the Supreme Court has once laid down a principle of law as applicable to a certain date or a certain state of facts, it will adhere to that principle and apply it to all future cases.
Basahin ko yung kay Rico Piñaranda.
All right. Okay, Rico.
Rico Piñaranda.
Okay, so moreover, the event about which Rico Peñaranda, the civil registrar of the municipality of Tarangnan, Samar, put in the civil registry form number 1A he issued was the record of the birth of a certain Francis Leo Marcos, Antonio Marcos, which allegedly took place on 29 September 1979. Per the copy of the certificate of live birth of Francis Leo Antonio Marcos, the local civil registrar of the municipality of Tarangnan, Western Samar at that time was Guido B. Rubin. Necessarily, Peñaranda's knowledge of Francis Leo Antonio Marcos' birth record allegedly made and entered in the local civil registry on 29 December 1979 was based merely on his general impressions of the existing records in his office. Furthermore, the certificate of live birth of Francis Leo Antonio Marcos shows that his mother, Remedios Baking Antonio, and father, Pacifico Edralin Marcos, were not married, and the affidavit of acknowledgement, admission of paternity appearing at the back of the certificate was not subscribed by Pacifico Edralin Marcos. Given the statement in the certificate of live birth of Francis Leo Antonio Marcos that Remedios Mangosen and Pacifico Edralin Marcos were not married, and there is no acknowledgement of paternity of Pacifico Edralin Marcos pursuant to Section 5 of Act number 3753 and Article 280 of Civil Code of the Philippines, the local civil registrar has no authority to make or record the paternity of an illegitimate child. In Roses versus Local Civil Registrar, it was written that, upon the other hand, Section 5 of Act 3753 specifically ordains in the penultimate paragraph thereof that in the case of an illegitimate child, the birth certificate shall be signed and sworn to jointly by the parents of the infant or only by the mother if the father refuses. In the latter case, it shall not be permissible to state or reveal in the document the name of father who refuses to acknowledge the child or to give therein any information by which such father could be identified. Similarly, Article 280 of Civil Code of the Philippines provides when the father or the mother makes the recognition separately, he or she shall not reveal the name of the person with whom he or she had the child, neither shall he or she state
Last page.
any circumstance whereby the other parent may be identified. That both legal provisions explicitly prohibit not only the naming of the father of a child born outside wedlock when the birth certificate or the recognition is not filed or made by him, but also the statement of any information or circumstance by which he could be identified.
Last page. Last page.
Yung kay Rico Pinalando, tapos na po yun.
Tapos na.
Tapos na,
Yung sa
okay.
last page.
Okay. Alright.
Balik tayo sa work po.
Alright. Ito po yung final judgment dito sa kaso na ito. Basahin ko po. Wherefore, premises considered, the appeal is granted. The judgment of the Metropolitan Trial Court, Branch 28, Manila, dated 4 August 2022 in criminal case number M-MNL-20-04180-CR is reversed and set aside. Accordingly, the accused appellant Norman Mangusin A. Antonio alias Francis Leo Marcos A. Antonio is hereby acquitted of the offense of violation of Sections 1 and 3 of Commonwealth Act number 142 as amended by Republic Act number 6085 for failure of the prosecution to prove his guilt beyond reasonable doubt. Alright, so maliwanag po na ang decision po ng Metropolitan Trial Court noong August 4, 2022 ay na-reverse and set aside. And here comes. Francis Leo Marcos A. Antonio is hereby acquitted
Whew.
of the offense of violation.